Let's say that the Court of Appeal had said that we interpret this phrase in the sense that only if the candidate gets more invalid votes than the other, which would, of course, be quite absurd. But suppose they had said that. So then it is your opinion that, well, it may be absurd, it may be crazy, but that's what they said, so it's final. I just need to know where, if there are some limits, at least in your thinking or not.
My Lord, in respect of the sovereign pronouncement by the Guyanese Parliament in enacting the CCJ Act, and in respect of the provisions of the Constitution, I say with regret that on the authorities, as silly as that proposition is, and of course we are not dealing with that in this case, that's a hypothetical. What the Court of Appeal has said, as your Lordship has quite correctly put it, is that more votes means more valid votes. That's all that they have said.
Mm-hmm.
Now, if they had said that more votes means invalid votes, this court has no jurisdiction to trespass on that. Once it is the provisions of Section 4.3 are there, and once the provision is cast in the terms of the constitutional provisions, that this one is.
Let's take it a step further, because like Justice Witt, it's important to try to see what the parameters are with which we are dealing. You can have a situation where the application which is made to the Court of Appeal on its face falls under 177.4, but the response that the Court of Appeal gives to it is one which someone else takes the view, this court takes the view, did not fall under 177.4. Or you can have a situation where the application which is made to it is made purportedly under 177.4, but does not really fall under 177.4 on its face. Are you also saying that the Court of Appeal has the competence to deal with that application, and this court, any other court, is stuck with whatever response the Court of Appeal gave?
Your Honors, that is the result which deeming provision, such as the one which is contained in the Guyanese Constitution with respect to exclusivity and finality, and the conjoined effect of the CCJ Act at Section 4, that is the conclusion that we are drawn to. And it is, I pointed out that as it is a position which has never, your Lordship asked a question earlier about me asking the court to find for the first time. But it is a position which is well settled by authority and which has never been the subject of rebuke in analogous circumstances Lee versus Asher, which Mullina's friends cite as authority for the proposition that there is some jurisdiction in an appellate court to reverse a superior court. You're not dealing with an inferior tribunal here, the severance benefits tribunal. We're dealing with a superior court. Lee versus Asher, the clause in Lee versus Asher spoke to, there were two exceptions to the principle of finality in that case. And Lord Mance expressly says in the paragraph before the one conveniently cited by my learned friend, Mr. Mendel, that the first question that he has to determine is the question of jurisdiction. And unless you fell within those two exceptions, you were out. And
I want to pursue this a little further, Mr. Jeremy, because I think this is really the nub of this case. Well, it is an important issue in the case. If a matter which properly falls under Section 163, which therefore is capable of being appealed right up to this court, if such a matter were to be improperly brought before the Court of Appeal, purportedly under Article 177(4), then if your view that you take is correct, then you see nothing wrong with the Court of Appeal then usurping what the Constitution says falls under the exclusive jurisdiction of the High Court and itself ruling on that matter, and then there's nothing anybody can do about it.
My Lord, I'd like to carry you back to just two cases to illustrate the strength of this point, because it's an important point. I don't think it forms the nub of, I don't agree with you, Your Honor, that it forms the nub of this case, because I do not agree that the Court of Appeal did as you hypothesized. But if you look at
Mr. Jeremy, it will help me if you were to answer the question in principle and then take us to the cases. Could you help me, please?
Okay. In principle, Your Honor, the court has no jurisdiction to decide whether, upon the material which is placed before it, another superior court granted exclusive and final jurisdiction in a matter. This court has no jurisdiction to determine whether that superior court was wrong. And the authority for that proposition is to be found in the cases of Re-Racal, which is at page 3313 of the record.
Yes, you're taking us to it before by Lord Diplock.
No, well, there's a bit below where we had got. He said, Lord Diplock continues, my lords, described by Lord J's decision to dismiss the DPP's application as a refusal or renunciation of jurisdiction seems to me to involve a misuse of the word jurisdiction. His jurisdiction was to decide whether upon the material placed before him, the application should be granted or refused. in deciding that it should be refused, he was exercising his jurisdiction just as much as if he had decided that it should be granted. And I just like to point, Your Lordship, to one other case in the time which I have. It's the Dan Silvi case at paragraph 50, speaking of Seniaki versus Navarrete, where it was held that the finality clause applied, Your Honors, even to jurisdictional challenges. That's at paragraph 50, and that is a decision of Lord Clark on an appeal from the Supreme Court of Mauritius. And I asked my learned friends to concede that they are asking this court to find for the first time that it has jurisdiction in similar circumstances. My Lord, those are the submissions for the first named response.
Yes. Thank you very much, Mr. Jeremy. We take a break here. It's about almost 11. Now, let me find out, Ms. Kai Thomas, do you propose to make oral submissions? Did you send in any written submissions? You're on mute.
No, please, Your Honors. We do not propose to make oral submissions.
Okay, thank you very much. So
Very
we'll take a, thank you. We ask you not to come out of the court to press the red button. Do not. We will reconvene at 11:15.
Culture Radio.
Covering Guyana from coast to coast.
Demerara and Essequibo 99.1 FM.
Berbice 99.5 FM. Culture Radio. Culture Radio, keeping you informed.
Demerara and Essequibo 99.1 FM.
Berbice 99.5 FM. Culture Radio.